All right, let the record reflect that the jury is seated, state's attorney's present, defendant, defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict?
Yes, we have.
And is it the unanimous decision of all of the members of the jury?
Yes.
Thank you. You can hand it to the bailiff. We, the jury, find the defendant, Asa Joseph Jones, guilty of aggravated assault as charged in the indictment. It's got the signature and the printed name of the foreperson. Would either party wish to have the jury polled, Mr. Burbank?
No.
Mr. Coleman?
No.
Any reason at this time then not to accept the verdict?
After the stages.
No.
All right, then at this time, ladies and gentlemen, Mr. Jones, I accept the verdict of the jury and find you guilty of aggravated assault. What that means is that the first phase of the trial is over and we'll now move into the second phase. Obviously, it's 10 minutes to 5, so we're not going to get started on that this afternoon. We'll get started first thing in the morning. Before we go any further, Mr. Coleman and Mr. Burbank, do either of you have any objection to the alternate being excused at this time?
Yeah.
So we do want to thank you so much. You'd be surprised how many times we use our alternate. And so I don't want you to think that you wasted your time, because it does happen quite often that we use our alternate. But at this point, you don't have to wait anymore. So when you leave this evening, you don't have to come back tomorrow. If you need anything for your employer today, you can ask the bailiff and they'll let you get that as well on your way out. What I'd like to do is get started tomorrow morning at 9 o'clock. You're still under all of those previous instructions and rules that we talked about before. So keep all of those in mind, and then just gather a little before. Do you want me to have them wait back here while we clear things out, and then you guys can take them out in just a few minutes? Let's do that. And the alternate, you can either go ahead and leave now, but the rest of you, if y'all want to go back into the jury room, once we have the courtroom cleared out, the bailiff will let you guys go. Yes. Oh, don't forget your badge, sir. Thank you, Mr. Coleman. And thank you. Right. Thank you, Mr. Coleman. Mr. Burbank, at this time also, for the record, I am going to revoke any bond amount that has been set for Mr. Jones. So there's no bond amount. You wouldn't be able to bond out at this point, is all that means. I'm going to stay and go ahead and work on the charge. I would anticipate we would get to that fairly quickly tomorrow. Kind of check your emails this evening. I'll email it to you as soon as I have that done. And then we can maybe get here at 1:45 or so in the morning and take a look at it as well.
Can I approach for a second?
Sure. All right, Mr. Coleman, the state has the right to open and close closing arguments.
State waives its right to open, but reserves its right to close, Your Honor.
Thank you, sir. Mr. Burbank, you may proceed.
Sometimes as a defense attorney, it's kind of hard when you stand up in front of a jury after the guilt innocence and you return a verdict of guilty, because you kind of put up your defense and what you think is relevant to the case. And sometimes people think, well, if they're guilty, they just don't believe you. I have a little bit of a different outlook in that, as I said, and Monday, we could not come up to a decision. I told you I believed in the system, and I do. I may not agree with your decision, but I respect it because I respect the system. And this is what we asked you to do. Now, though, we have to decide what is proper punishment. And I know there is not a person on this jury that has a blind eye or is oblivious to what's going on in society today. You hear it every day. I'm busy, sad to say, for representation of what's going on. And when you put together the violence and things that are happening, it makes people mad. And it should. But as I sat here this week, as I sat here at night, because when I get into trial, my focus is you, ladies and gentlemen, because that's the presentation of my case and my client that I've known. And I look at things. And I look at things over the 36 years that I've been practicing in reference to different cases. And I want to submit some things for your consideration, and it's not evidence. I don't condone crime. I represent people that have been accused of crime. And I represent that I very seriously take it that I represent my client to make sure the state proves their case and presents the best I can to the jury. In this case, there's some differences here. I think the end result very lucky for both sides that we're not in a murder trial and another person has been killed. But there's differences. And the difference is that this crime, as you looked at the jury instruction yesterday, did not have the definition of intentional. It had knowingly and recklessly. And I would submit to you it was probably recklessly. And that's a difference in the legal world. And you're probably wondering where I'm going with this. Asa was on probation. Yeah, you know that. It's a given. Misdemeanor. Never been convicted of a felony. Okay, so he is eligible for probation. Asa was going to a friend's house to go fishing. There's nothing to convert that. Anything that says he wasn't doing. Hunter, excuse me. When you look at crimes and offenses that have happened in this society, this is not a crime in where he says, I got mad at you, I don't like you anymore, I'm going to kill you. So he goes to the house or he goes somewhere and shoots and kills somebody. This isn't a crime that says that I'm going to sexually assault somebody and I groom you and it comes over a period of time and it happens. Or it's an aggravated robbery in which you intentionally want to go into a store to rob, you have a gun, and as a result of your actions, you pull the trigger and you kill the clerk. That's intentional. But there's no evidence that was presented that at June 12th, okay, in 2025, that as he set out, and you know that he was downtown at one time about 3:30, 3:45 in the afternoon, that he intended to be in a road rage on Eastex Freeway. Wasn't. Now, you heard his testimony yesterday, and that he felt threatened. Okay, now I understand you didn't think that it rose to the standard. I understand. But in his mind, he felt threatened. If he didn't, he probably would never have pulled a gun and did what he did, which is foolish. I'm telling you, guns don't solve problems. But in that moment, he thought that was the solution, right or wrong. He didn't go out to do this. He didn't go out to say, I'm going to rob you or I'm going to murder you. It could have ended that way, but not. And I think that's where the difference is. The other difference is, and I'm glad that Mr. Hunter Freeman is not dead from where it was. But it bothers me, and it's just me, that somebody would say, I caused this. I taunted him. I said, come on, do it. Basically, if you're going to do it once he showed the gun, if you take it that he brandished it or he waved it at him, come on, shoot me. And I wasn't going to back down because that's how I was raised. That bothers me. And I ask you to consider that in the deliberation. And that both of them should have parted ways and gone their own ways. Both of them, especially, and Mr. Freeman's included, that if you take it that he's doing 70 miles an hour at 4 o'clock in the afternoon on the Eastex Freeway, and we saw how busy it was, doing what they were doing, would have had some type of sense saying, I'm not going to taunt him. I got to get away from this. Just as Miss Jennings said, what are they doing? They're going to kill somebody. But emotions, the time, the instance, neither one of them were thinking rationally. And I don't say this like I don't, because this isn't the way society is supposed to be. But I ask you to take that into consideration because I believe, and it's just my opinion and it's not evidence, it's just my opinion for your consideration, that it is a little bit different than other offenses and crimes that we usually see. People going to apartments, going after somebody, going by drive-by shootings because there's an intention of getting in the car and going and shooting up somebody or someplace. Or going up to somebody and shooting them because you don't like them at a fight or something like that, you know. But I submit to you that in this case, it was the heat of the moment and should never have happened. Asa is eligible for probation. I know he was on misdemeanor probation, but it's a little bit different if you're on felony probation. It's a little bit different environment on felony probation if you screw up. You know that there is rules and regulations in reference to what he's going to have to abide by, and I ask for your consideration in that. One of the things, though, is you would have to be or can be up to a 10-year period if you assess a 10-year prison term. So that's supervision for up to 10 years on this. If not, as the court has said, there is no jury, there's a hearing, and she determines, she being the judge, determines the violation and whether or not to be punished. I ask you to consider that. If it is not probation, I ask you to consider it when you decide the term of years. I don't believe it's worth 40 years. But that's up to your decision. One of the things I do want to point out to you is this. As page 4, and that is he's never been convicted of a felony and no more than 10 years assessed. The court will assess the time. I will tell you that it will be 10 years on probation. One of the things is here is the fine. The fine does not go to the complainant or the victim. So when you look at that, it goes to about 32 organizations. One time when we were waiting for a jury, a court, a judge and I, and some other prosecutor. It was like 32 state organizations that get a little bit of whatever the fine is. So I want to let you know that because a lot of times jurors will say, does it go to a victim or something, restitution, and it does not. I will submit to you, though, that if you consider probation and with a little more hammer, you can assess a fine of $10,000. I would recommend and hope if you did consider that you wouldn't make it payable at this time, but that you would put it over his head, saying, okay, you can still be assessed it if you screw up. I know that you deliberated in there. I know that you looked at everything, since I wasn't spying on you, but that you took your time and you did what I asked you to do and what Asa asked you. I ask you to do the same thing and take everything into consideration. There's no doubt that society today, the youth, we have a problem. But in the same token, I'm going to submit to you that this offense, this case is kind of unique and different. And that somebody didn't set out to do this. Somebody didn't say this morning, this is what I'm going to do. It is a terrible mistake. He has to pay for what he did. Thank God no one was killed. And I ask you to take consideration of that. And thank you for your time.
Mr. Burbank. Mr. Coleman.
Thank you. May it please the court. Mr. Burbank, ladies and gentlemen of the jury. I want to begin like I began during the guilty innocence phase, where I gave my closing remarks about thanking you all for your time. Thank you for your attention. And I want to say that when I first heard about this offense, I heard about it on the news. I vividly remember it back in June, on June 12th of 2025, watching it on the news, and it offended me deeply. It very deeply offended me that someone over something so stupid and trivial as being cut off would shoot somebody in the face. And when this case landed on my desk and I started to review the case and the reports, I remained offended that not only that this was a criminal offense, it offended the penal code, but it offended my sense of human decency. It offended my sensibilities as a member of this community, because it shouldn't be this way. It should not be this way. Mr. Burbank would draw a distinction and everything. This is not the typical gun violence crime that we're seeing in Jefferson County. I'll submit to you that it is. This is typical of someone who just has a dispute with somebody and instantly goes to the gun, resorts to the gun to settle that dispute. It doesn't have to be this way. It shouldn't be this way. And you can send a message via your verdict to say, we will not tolerate that anymore. This defendant has asked for a second chance. But you've heard testimony and evidence about the fact that he's had at least 2 previous probations. He violated his probation, the current probation, by committing this offense. You saw in that video, he was leaving the probation department. He just met with his probation officer before pulling out a gun and shooting somebody in the face. We had this back and forth discussion during jury selection about rehabilitation. Rehabilitation is great, but remember, it's one of those 3 goals of the criminal justice system. One of which is to punish, the other one is to deter. Punishment, deterrence, and rehabilitation. Rehabilitation only works if somebody's receptive to it. If somebody wants to be rehabilitated. 3 previous unlawful carrying of a weapon cases wasn't enough to rehabilitate this defendant. Okay? It would be nice if we can figure out what his malfunction is, what his defect is that makes him recidivate, that makes him revert back to crime. But that's not our job. Not my job. I'm a prosecutor. Not your job. Your job is to see that justice is done and render the proper verdict in this case. It would be nice to know that, but whatever it is, it's in his nature, ladies and gentlemen. And insanity is defined as doing the same thing over and over and expecting a different result. And if you put this defendant on paper, as they call it, and with the promises and conditions to, I guess, I promise not to shoot somebody in the face again. That's all it is. It's a promise. He made the same promise when he was on probation before. The same promise not to commit a crime. Ladies and gentlemen, that's offensive as well. It offends me that he would come in here after committing this offense and look you in the eye and ask for probation. There are cases that lend themselves to probation. There are situations in defendants and circumstances that lend themselves to probation. A DWI, first time DWI, somebody who evades from the police, they didn't want to pull over because they were scared, something like that, some property crime or something like that. There are those cases that lend themselves to probation. But it is offensive to ask for it in this case under these circumstances. And I just can't believe that he would even come in here with a straight face and ask you to do that. Ladies and gentlemen, you've got a duty to protect this community, to protect this society. You may not think that what you do in the way of your verdict makes that big of a difference to protect our society, but think about this. Had he been in jail for that previous offense that he was on probation for, then Hunter Freeman may not have been shot in the face. If you let him walk out of this courtroom, who knows what, if anything, he will do. He just doesn't get the message, okay? You also have a duty to Hunter Freeman, a duty to render a just verdict. And when I say justice, I'm talking about equity, something that is fair and on par with the harm that he has suffered. Letting this defendant just walk out of this courtroom having just been minorly inconvenienced is not fair or equitable when compared to the harm that Hunter Freeman has suffered. You heard of the long-term effects, having to recall that event over and over, the loss of hearing, the loss of his teeth. That pales in comparison to probation. This defendant, let me say this, 3 weeks from now, you and I, we're going to go on about our business. 3 months from now, you will struggle to remember the names of the participants in this trial. My name, Mr. Burbank's name. 3 years from now, this will be a distant memory for you, for all of you. But 3 years from now, Hunter Freeman will still be dealing with the consequences. He'll still be reliving this. He will still have the physical impairments from this offense. 3 years, 30 years from now. So I submit to you that putting him on probation is not on par. It's not equitable. It's not justice. So please, I implore you, don't do it. Do not put this defendant on probation. And when I talk about the community, I'm not talking about some amorphous term, some term that doesn't really apply to actual people. You saw that video of Miss Jennings' 11-year-old son. He's a victim too, by the way. He saw all of this blood and the aftermath of this individual being shot. You saw how he looked, the look of fear and shock on that child's face. He's a victim as well. Anyone else who would have been on Eastex Freeway that day, they were potential victims. Anybody that would have been in the backseat of the Suburban, they were potential victims. Just a few things for you to consider. I submit to you in your deliberations is you can consider all the totality of evidence. You can consider those previous convictions. You can consider how evasive he was. I'm being generous by saying evasive. You can infer that he was just straight up lying to you when he said in all 4 instances, he can't remember where he got those guns from or who he got them from. And in this case, that gun is still out there somewhere, waiting to rear its ugly head, and who knows, God knows who's crying, because it's going to be passed around again on the streets. So you can consider that. You can consider that in your deliberations and in your assessment of the punishment. And I brought the evidence of that urine incident in the jail. It's kind of, I will concede it's kind of trivial, but I brought you that evidence because even in a confined, controlled situation there with guards and everything, this man can't follow the rules there. He can't follow the rules on his stand, can't follow the rules of the court. What makes you think, you saw his demeanor up there, what makes you think he's going to follow the rules of probation immediately? Okay? Don't be fooled. He wants to come in here, cry the crocodile tears, say the right words that I am convinced he practiced before he got here, and try to snow you into giving him a probation. And lastly, his demeanor. His demeanor, I think, is indicative as well. While he may have said the right things, you saw how he was toward the end of my question. I suspect that had I pressed him a little bit more, a couple more questions, the real Asa Jones was about to come out. You saw it. He was ready to go. And had I thought I had a little bit more leeway, I would have gone there with him too. But you saw it, you can assess that. And what I'm saying is, not to be mean-spirited, those are all things that you should and could consider in determining the appropriate punishment for this defendant. I'm just going to briefly refer to my little chart here because I think it's helpful to see. We can talk about the punishment range, but I think it's helpful to actually see the punishment range. Probation, all the way up to life in prison. I submit to you, this is not a life in prison case. So let's just take that off the table. There are, believe it or not, more egregious cases out there that merit a life sentence. However, on the other end of that spectrum, for all the reasons I just said, this ain't no probation case either. So let's take probation off the table. Now you're left with 5 to 99. Even before Hunter Freeman took the stand, and he and I didn't confer about this and talk about this, in my mind, I already had an idea of what this case was worth, so to speak. And I was thinking that you take the top end of this punishment range off the table. Certainly, based on everything I just said, you know where I stand on the bottom end of the punishment range. I think you take that bottom end of the punishment range off the table, given his priors, given the body armor. I almost forgot about the body armor. You can consider that. That's in evidence. Who drives around with body armor if they're not law enforcement? Take all that stuff into consideration. His priors, the body armor, the previous guns that he suddenly can't recall where he got from. I submit to you, and most importantly, the nature of the offense. And I'm not going to rehash the nature of the offense. People could have been killed. Other people could have been killed. Hunter Freeman could have been killed. That's why I submit you shouldn't consider the low end. That's why I think you get somewhere right here. And again, I never even talked to Hunter about what I thought the case was worth. But I think remarkably, Hunter and I are on the same page. I will concede. I was thinking probably around 35 is what I was thinking. He was at 40, but I think we're in the same ballpark. And I say that because again, equity, parity, on par with what the suffering that Hunter had to go through for the next 30 or 40 years. Couple things. whatever sentence you assess this defendant, the jury charge says that you can consider the fact that parole exists. There's some very specific language in there. I would invite you to look at that language about parole, because it also goes on to say, well, think back. There is a possibility that no matter what sentence you assess, that this defendant would be eligible for parole, with having after doing half of his time. Okay, there's that possibility that he can be eligible for parole. However, that jury charge tells you that's not guaranteed, and that's not something you can say specifically what happened to this defendant. Okay, but you certainly can consider it in the existence of parole and the possibility of parole after doing half of his time. You can consider that in assessing your punishment on this punishment scale, in this punishment range. And another thing, Mr. Burbank and I do agree on the fine. I would suggest to you, you don't spend any time on the fine. A lot of jurors get back there and they get hung up and start negotiating about the fine. That fine's not going to go to Hunter Freeman. Who knows what the state will do with it? I will submit to you that you don't spend, even if it gets paid, typically it doesn't get paid. Even if it gets paid, it's going to go to the state. Who knows what the state will do to it? Sentence him within this range, somewhere between 25 and 50 years. Not because I say so, but because that is justice, ladies and gentlemen. That is both punishment, it's deterrence, and believe you me, it's deterrence. The jail will hear about this. The other inmates will hear about this before this defendant gets back to the jail. That's how it works. And also the general public will hear about it. Any other defendant who would even think of doing something so stupid and just reckless, hopefully will reconsider that punishment, deterrence, and while he's in prison, if he chooses to, he can take advantage of being rehabilitated. But that's what I'm asking you to do. I have faith in you. I trust you'll make the right decision because you did the right thing during during guilty innocence. And I'm asking you to do just that this time around. Thank you.
Thank you, Mr. Goldman. All right, ladies and gentlemen, that's all the evidence in the court's charge and closing argument. I'm giving the charge to the bailiff. She'll get you situated in the jury deliberation room where you will deliberate, and we'll be in recess until you reach a verdict on punishment. You guys can go back with the bailiff. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. I've received a message that the jury's reached a verdict. If you can bring the jury in. All right, let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. I would ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am.
Thank you. You can hand it to the bailiff. We, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assesses punishment at imprisonment in the Texas Department of Criminal Justice for a term of 7 years and no fine. You can have a seat. Does either party wish to have the jury polled?
No, Judge.
No, Your Honor.
All right, then, any reason not to pronounce judgment at this time?
No.
Stand.
Then at this time, Mr. Jones, in accordance with the jury's verdict, again, I've already found you guilty. And at this point, you're now sentenced in accordance with that verdict to a term of 7 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You've been handed a couple of documents. One is a certification of your right to appeal. You do have a right to appeal, and you can talk to Mr. Burbank about that. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have any questions about the laws that make you ineligible to possess a firearm or about how long that lasts, you can also talk with Mr. Burbank. Mr. Burbank?
You're awesome finding.
Because he was found guilty of the indictment as charged, there is that affirmative finding of the presumption of the deadly weapon. So that will go into the judgment as well. You will be remanded to the Jefferson County Sheriff's Department until your transportation to the Texas Department of Criminal Justice. You can now go back with the bailiff. Ladies and gentlemen, I'll come visit with you in just a minute.
I have excuse y'all.
Thank you, Mr. Coleman. Thank you, Mr. Burbank. Y'all are both excused. The court will be, you can go to the back and then I'll let you know when you come through.